Welcome back to the video lecture on East Asian state leadership in international law. This time, we are going to discuss the Japan's Fukushima nuclear power plant contaminated water discharge. As you know, the 2011, the nuclear accident caused by the Tohoku, the earthquake, and the tsunami in Japan is a potential disaster that can occur to any state that uses nuclear power at any time. Since soon to be discharged, the contaminated water will be dispersed into high seas, it will affect not only Japan's neighboring countries, but also interests of the entire international community. Therefore, the safety of the released radioactivity wastewater should be accurately verified through multilateral international cooperation, and Japan should prioritize dispelling international skepticism regarding the safety of wastewater by providing information in a transparent and continuous manner. Until trust is established among neighboring countries and with the international community regarding Japan's wastewater treatment, Japan needs to postpone the discharge of the contaminated water. Japan's position regarding the release of the Fukushima nuclear power plant wastewater can be summarized into three key parts. The first, Japan did not violate United Nations Convention on the Law of the Sea regarding the protection of the marine environment. Although the convention imposes general obligations on contracting parties to protect preservation of the marine environment, and the mandate legislative actions to prevent, reduce, and control pollution of the marine environment from land-based sources, it also recognized the broad discretion of the contracting state in such matters. The second, Japan did not violate the London Protocol and London Convention regarding the prevention of the marine pollution, which prohibit dumping of waste and other matter. According to protocol, dumping means any deliberate disposal of waste or other matter into the sea from vessels, aircraft, platform, or other man-made structures at sea. As such, the discharge of contaminated water from land-based nuclear power plants falls outside the scope of dumping. The third, the contaminated water Japan wants to dispose is not harmful to the marine environment or people and is comparable to the emission practice of neighboring states such as China and Korea. In conclusion, none of Japan's discharge plans are in violation of international law. In light of the lack of the clear scientific evidence regarding safety of treated contaminated water, neighboring countries have expressed their concerns regarding the potential risk posed by the discharge of the wastewater. In response to Japan's unilateral decision to proceed with the discharge without prior consultation with adjacent countries, various measures are being discussed in terms of the international litigation. Such measures include provisional measures and contentious proceedings before the International Tribunal of the Law of the Sea, initiated by the sovereign state, as well as advisory opinions from the International Court of Justice through the international organizations, or ITLOS in a case, through an international agreement related to the purpose of this convention. For the ITLOS to decide upon the appropriate provisional measures, the urgent risk and serious harm to the rights of the parties concerned need to be demonstrated. Although Japan has formally announced its plans to discharge, proving the above two requirements in the absence of an actual discharge will be challenging. Similarly, in contentious proceedings, Japan's violation of international law regarding the discharge of radioactive contaminated water from Fukushima must be contested. Although the plaintiff state must proceed with the legal procedures promised, on Japan's breach of international legal obligations, since the implementation standard of international legal obligations are essentially set very minimum level, it will be difficult to argue that Japan's violation of international law regarding discharge of wastewater is a substantive breach of its obligations. The final report from the International Atomic Energy Agency, IAEA, in last August is expected to serve as a compelling evidence to support the contested scientific safety. However, Japan's action regarding the release has been an ongoing issue given the lack of international cooperation, including prior notification or provision of the information and adherence to procedural obligations regarding the conservation of the marine environment, including execution of the environmental impact assessment. This is also closely related to the ongoing lack of communication among the parties involved. Ultimately, from an international legal perspective, it is highly likely that Japan will be held in procedural rather than substantive violation of the post-discharge regulations under international law. Regarding the ocean area beyond the national jurisdiction of individual states, the constantly evolving norms of the international ocean environment has adopted a forward-looking stance. Japan's argument that the discharge of the radioactive contaminated water from the nuclear power plant is simply not a violation of international law and is comparable to the emission standard of neighboring countries is disappointing as it indicates Japan's attempt to evade international legal responsibility by complying with the bare minimum of international legal standard. Japan's international legal operations regarding international environmental issues, which do not reflect morality and the zeitgeist of the time, which is the spirit of the time, raise doubts as to whether Japan is truly fulfilling its role as the de facto second or third in command among the liberal democratic states, maybe second or third only to the United States and Germany. In cases where scientific evidence is required, it is necessary to consider the high probability that prolonged litigation could fail to prevent discharge of contaminated water. Even if the litigation is successful, there is no guarantee that it would be effectively sanction Japan's discharge. Conversely, if the litigation were to end in defeat, there is concern about potential legitimation of the Japan's discharge. Furthermore, at present, it is unclear which sovereign state may bring the suit in the context of these international legal proceedings. Recently, regarding climate change issues, the International Court of Justice and International Tribunal for the Law of the Sea has undertaken leading roles in developing advisory opinions, and greater attention has been placed on the positions of the Pacific Island states, which are formerly a nuclear testing site. Despite the legal significance of advisory opinions from the international judicial bodies, it is difficult to consider such a method are effective means to prevent Japan's discharge of contaminated water. Therefore, it is important to approach the issue with a long-term policy perspective rather than a narrow assessment, solely focused on the current discharge decision. It is worth emphasizing once again that the nuclear accidents Japan experienced during the 2011 Tohoku earthquake and tsunami in Japan is a disaster that can occur in any state that uses nuclear power. History has proven this. And yet, there is a clear lack of international norms specifically addressing the disposal of nuclear waste into the ocean. Hence, Japan's action regarding discharge of contaminated water from the Fukushima nuclear power plant is a significant precedent that provides a valuable opportunity for the international community to dictate for the direction it's aimed to pursue. The failing to seize such opportunity would be a regrettable occurrence for the international community. Regarding this matter, the further complexity arises from the interplay with the domestic political factors. In the case of South Korea, the Federation for Environmental Movement in Busan, one of the NGO, they already filed the lawsuits against the Tokyo Electric Power Company in Busan District Courts in April 2021, seeking to prevent the discharge of the Fukushima radioactive wastewater into the ocean. In July 2022, the Tokyo Electric Power Company argued that the Korean courts lacked international jurisdiction over the lawsuit since the discharge of the wastewater from Fukushima nuclear power plants had no substantial connection to Korea. From the perspective of the individual countries that are expected to be affected by the release of the contaminated water from the Fukushima nuclear plants, they should continue to exercise their inherent rights even after discharge has been initiated, such as the demand for ongoing environment impact assessment, including marine ecosystems. Furthermore, effort should be made to establish a funding system for compensating the citizens of the state that will likely be affected by the discharge of the contaminated water. And in the process of establishing such a funding system, Japan should adopt forward-looking approach. Thank you very much for your very kind attention.